The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon and welcome. I'd like to welcome counsel as well as those watching us through our Supreme Court Live channel. We have read your briefs and are looking forward to counsel's arguments this afternoon. I would now ask the clerk of the appellate courts, Mr. Doug Shima, to please call this afternoon's docket. Mr. Shima.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Thursday, December 17th, 2020 consists of one case. Appeal number 122621, State of Kansas versus Jerome Cheeks, Wyandotte County, briefs both sides. The appellant has reserved 4 minutes rebuttal. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
May it please the court, I'm Joseph Desch and I represent the appellant, Jerome Cheeks, and we're present and ready for argument.
May it please the court, the State of Kansas appellee appears by Assistant District Attorney, Wyandotte County, Daniel Obermeyer, present and ready for argument.
Thank you, counsel. Mr. Desch, you may begin.
Thank you, Your Honor. Just for my background statement, I'm going to cheat and read here if you don't mind. Jerome Cheeks was convicted of second-degree murder in 1993 for a 1992 offense, and that conviction was affirmed on direct appeal and after some other post-conviction motions. Pertinent here, in 2009, Cheeks filed a motion for DNA testing under KSA 21-2512. The district court denied the motion since Cheeks, his conviction was not for a first-degree murder, which was a qualifier for testing on the statute. This court reversed, finding that Cheeks was entitled to consideration on the merits on equal protection grounds. Now on remand, the district court again denied Cheeks because he had been paroled, another procedural issue qualifier. On appeal, this court again reversed and remanded for consideration of Cheeks' petition on the merits. After the second remand, 4 years later, or 3.5 years later, the district court again denied the motion on the basis of State versus LaPointe, a February 15th, 2019 decision of this court, which overruled, at least to an extent, this court's prior ruling in Cheeks' 2013 decision. Now, when discussing this case, I'll be referring to the two prior appeals of this court as Cheeks 1 and 2, if necessary, to make those clear. But of course, that's not including the direct appeal and the other prior appeals. So to get started, we're here for the third time on one motion on the exact same grounds as the first round. Cheeks' second-degree murder conviction does not qualify him for DNA testing under KSA 21-2512, or at least that's the district court's take on it. A few days prior to the release of LaPointe on the merits, the state conceded in writing that Cheeks was entitled to DNA testing under the statute and he'd met the qualifiers. However, I suppose there were some other issues. He qualified for testing. Now, a few days later, LaPointe comes out and the state decided, well, let's file a supplemental and say, well, he's procedured out because he no longer qualifies as a second-degree murder conviction. I'd respectfully submit that the ruling LaPointe was kind of a sledgehammer to swat a fly, and that it didn't necessarily need to overrule Cheeks. However, I guess the question is, what is LaPointe's actual effect on Cheeks now, considering the mandate rule and considering the law of the case? Now, I'm going to go into LaPointe for a moment here. It made sense to deny LaPointe because his conviction was of a different character and certainly of a different level or class of offense than Cheeks here. The circumstances were different too, because LaPointe was sentenced in a very high level to a considerable sentence because he had a criminal history issue that seriously affected the numerical sentence. But in I'm
Counsel,
sorry.
but isn't the point or the holding of LaPointe is that we don't determine similarly situated under that statute based on punishment. It's based on the elements of the crime.
Well, I would say that's correct, Justice. I'm sorry, but I would also say that we should consider amending that, or at least clarifying that LaPointe decision, because it was just overly harsh on people like Mr. Cheeks, who were sentenced for murder 1, even though he was convicted of murder 2. If you really get down to the point, if you look at the statutes in 1969, which the one under which Mr. Cheeks was convicted, he was sentenced to the maximum possible crime and the maximum sentence that a first-degree murder case would have been. Now, we are talking about 1992, which was a little different because the statute for first-degree murder was amended by that time, and it changed basically changed the good time allowance for murder 2 and took it away from murder 1. In all other respects, a life sentence is a life sentence, I'd have to say, because you're going to be on parole the rest of your life and you can be dragged back into the prison system at any time for any violation for the rest of your life. So I'd submit that the class of offense should be the qualifier rather than the actual numeric or in the actual statute number.
But doesn't the legislature tell us what the qualifier is in terms of eligibility?
They do. And I want to make a point there, and I'm not trying to avoid your question. I want to just put this out there as best I can. The qualifiers are murder 1 and rape. Both of those offenses are different levels. Murder 1 is, and at this point, an off-grid offense. Rape is either a level 1 or a level 2 person offense. Just like before, when we're in the indeterminate sentencing scheme, rape is a B class offense, just like murder 2, and murder 1 was a class A. But the similarity of the available sentences for A's and B's remains the same, and level 1s and level 2s. Or should I say off-grid and level 1, level 2. So I don't see any difference between a rape case and murder 2 because they're both level 1, level 2 cases. I can't see how those people are any differently situated when the penalties, the potential penalties, are exactly the same.
Well, I guess the point of the Cheeks, there were 3 of us, I believe, that descended in Cheeks 1. And the point of those descents was that, and the point of LaPointe is that, as Justice Wall tried to point to clarify, is that it isn't a punishment-based similarity. It is the statutory element, criminal statute similarity. And here it's up to the legislature, at least I think that was the point of LaPointe and some of those dissents earlier, to designate which crimes, not the punishments, but which crimes are eligible under the statute for subsequent DNA testing. It doesn't matter what the punishment is. They could probably specify a certain theft would be appropriate, but they for DNA testing. But it's crime specific, not punishment specific.
Yes, sure. I agree with you, but I also would have to say there's very, very little difference in the murder 1 and murder 2 statutes, especially during the old law scheme. They were both considered malicious offenses, and now we've taken away the malicious, and now it's just intentional with premeditation. Before it was premeditation, actually malicious was part of premeditation. So, and I'm not trying to argue, and I'm not trying to disrespect what you're saying. I understand the legislature has its job to do, and they choose what they want to choose. With all due respect, I understand the dissents as well in the Cheeks case, and I do understand the dissent from Justice Breyer in LaPointe, and that's kind of what I was trying to say, is that the LaPointe is just it had a correct result. It had the right decision for Mr. LaPointe. but it shouldn't be applied to Mr. Cheeks because the law of the case is Mr. Cheeks is entitled to DNA testing since 2013. And playing the waiting game, as the court did here, 3.5 years to give him, to follow the mandate does not seem like a justice to Mr. Cheeks when they had every opportunity to follow the mandate from the second one from 2015, and they didn't.
What happens to a mandate in a decision that is subsequently reversed by our court?
Well, according to our laws, nothing. The case on point right now is Clapus, and it goes through all of the things that came out from Collier, and it says basically that the district court can't change the mandate. The only court that can change the mandate is you, the Supreme Court, the one that put it down in the first place. So I suppose at this point, if you decide to change the mandate from before, you can, but there has to be, under the laws it sets, there'd have to be an exception or an exclusion. An exception under law of the case, or under the mandate rule, you would have to just change your minds. And I don't think that's the proper decision in this case, because Mr. Cheeks was granted the ability to have DNA testing on the merits. Well, actually not DNA testing, but have a determination on the merits in 2013. And we're just stalling him out. And I've already covered the majority of my materials as far as that goes. So I would just respectfully submit that I believe the class of offense, it should be the key, not necessarily the number of the offense. And because rape is not a mandatory life sentence, it's different in character than murder. So why is murder 2 treated differently than rape is? I guess that's the kind of the theoretical question. But I think they should be treated equally, because that's what the statute is intended to do, to give a post-conviction opportunity to people that are convicted of severe crimes and frankly, that are serving severe sentences. If I have any other questions, my time is up. Seeing none, I will cede the floor.
All right. Thank you, Mr. Desch. Mr. Obermeyer.
Madam Chief Justice, and may it please the court, I want to focus in on one thing that counsel said there, that it's the class of offense which determines whether or not a defendant is entitled to DNA testing under 21-25-12. I think that's explicitly what this court rejected in LaPointe, and that is not properly before this court today, insofar as he asks this court to sort of softly revive it by holding that Mr. Cheeks is entitled to DNA testing under this statute. I would ask this court deny it on those grounds, because this court has clearly held in LaPointe that it is not the class of offense that determines whether or not someone's entitled to DNA testing. So I ask this court to reject that outright. Regarding the merits of the brief, the state's first argument in this case is that the mandate rule, as Mr. Desch couches it, was never raised before the district court. What was argued before the district court was by the defendant himself. He argued that law of the case doctrine should apply to his to the court's proceedings, and that was tangentially addressed. And Judge Myers explained to the defendant that because the law had changed through LaPointe, that he no longer met the qualifying criteria for DNA testing. And that meets the second exception to whether or not even though the law of the case doctrine is, it's applicable on appeal. If the court were to apply that to the district court level, that would be controlling authority has made a contrary decision regarding the law applicable to the issues. And this court is in a position to make that controlling authority, and it did. As far as whether the mandate was followed, getting to really what I think is the heart of this case, again, not raised until appeal, is whether or not the mandate was followed. Cheeks 2, the last direction that this court gave to the district court in 2015, concludes the district judge's ruling denying Cheeks' petition is reversed, and the case is remanded to the district court for further proceedings under KSA 21-25-12. I submit to the court what everyone at the hearing understood as a review of Volume 9 will clearly indicate is that further proceedings means assessing whether or not he qualifies still. He still meets the qualifying criteria. So to the extent that the district court did that, it did follow this court's mandate. This court didn't mandate that Mr. Cheeks receive any specific DNA testing. So,
Counsel,
yes, Your Honor.
don't we have to read that mandate in conjunction with Cheeks 1's mandate, which really resolved at least whether the defendant was within the class eligible to have a determination on the merits?
I would submit to this court that it does not, because first, well, we're still dealing with whether or not, first, I don't remember what the precise mandate in Cheeks 1 was. I'll defer to counsel. This court can check, but I believe that the Cheeks 1 mandate was also for further proceedings. I could be wrong on that.
Yeah, I have it in front of me. The last sentence of Cheeks 1 is, we reverse the district court's ruling denying Cheeks' petition and remand this case to the district court to determine whether Cheeks satisfied the remaining statutory requirements entitling him to DNA testing.
And in that case, I just don't, I think that the court is still obliged to look at whether the case law changes, I guess that's my best answer to that question, Justice Wall, under the exceptions to the law of the case doctrine, even though that really only applies on review.
Are you essentially asking the court to recall the mandate?
Again, in Cheeks 1, this was not brought up before the district court as to whether or not Cheeks 1 operated to move him directly forward to full consideration of the merits. I'm not asking this. That would be the remedy that I would ask this court formally to do in this case. So there's no question whatsoever as to whether or not this court is or isn't ordering that DNA testing be ordered pursuant to the statute. That's the ruling I would ask this court to hold, and I would ask this court to hold, as LaPointe pointed out, that Cheeks 1 was wrongly decided, and that includes Mr. Cheeks, the judgment of this court that Mr. Cheeks was entitled to DNA testing. I think this isn't another defendant's case, and LaPointe specifically overruled Mr. Cheeks' case. So to that extent, I think that the state does have a good argument that the mandate should be recalled at that point if this court is acknowledging that Cheeks 1 was wrongly decided in the first place. I don't think that can be held against the district court in terms of deciding whether or not the mandate from Cheeks 2, read in conjunction with Cheeks 1, if that's what this court deems is appropriate. I don't think I think that that's an appropriate resolution to find that this court followed with the corpus of law regarding KSA 21-25-12. I do not have any further presentation in this matter. Unless there are any questions, I will yield the remainder of my time.
I don't see any questions. Thank you, Mr. Obermeyer. Mr. Desch, you reserve 4 minutes.
Yes, thank you, Your Honor. I must take exception with my colleague's position that that was not preserved for appeal the mandate rule. I'm going to direct you to volume 9 to client or the counsel's argument. My argument on point number 1, therefore, is that at some point, the Supreme Court in 2013 told this district court to consider the motion for DNA testing for my client. That hasn't been done yet. I'm still asking, or I'm asking the court to still hear that motion because of the Supreme Court's ruling back then. And the LaPointe decision did not state that we are specifically stating that this is retroactive and applies to Cheeks 1. Now, I don't know how you could do any better than other than saying, oh, I mean the mandate rule. Now, Mr. Dent is a completely qualified lawyer, and I have no disrespect to what he has to say, but I think he said that's the mandate rule. You follow what the court ordered. That's what the mandate rule is, and that's what he said. He did not say specifically the mandate rule, but I think impliedly he was asking that the court follow it, and that's what the court did not do.
Counsel?
Yes.
I have a
yes.
question about the mandate rule. If a court in a generic case issues a mandate and the mandate says apply statute X,
Certainly.
and then the next day the legislature repeals statute X, what's the district court supposed to do?
I think in that particular instance, they have to apply statute X because the repeal is prospective, just as LaPointe would be. In of course, that's my opinion. Obviously, that's up to you, you to determine. If I might make one more point as to Mr. Obermeyer's arguments, Cheeks was not wrongly decided. That is not at all what the LaPointe decision said. The Point decision said we overruled Cheeks to the extent that the length of sentence controls whether people are similarly situated. And that's why at the beginning of this argument, I was led to the arguments of the substance. And I think it is fair to consider the class of offense. But well, I'm going to leave that to you all to decide what's proper. But I don't think that the intention of, well, and I'm not sure you would be able to tell us better than what the intent was. I don't think the intent of LaPointe was to take the ability for DNA testing on the merits, or at least the merits of Cheeks' decision away. I think that that was 3.5 years down the line. Cheeks should have been given what he was supposed to be given due to both mandates. And I think it's unfair at this point and prejudicial at this point to take that away from him once he's already been given it 7 years ago. And that's what really all the arguments that I have prepared. If you have any questions, I'm happy to entertain them.
Any other questions? Thank you, Mr. Dash.
Thank
you to both counsel for your arguments today. We will take this appeal under advisement, and court is in recess until 9 a.m. tomorrow morning.
Thank you.